Hey, Daniel.
All right. Welcome back to the ongoing public hearings of the Environment and Transportation Committee. I am your friendly chairman, Kumar Barve. I am joined by the equally friendly vice chairman, Dana Stein, and the jolly gang of environmental transportation geeks. We have a number of bills today. We have first, and again, just to reiterate the policy, we do bills in numerical order, but we group together the bills by our frequent flyers. And so the first two bills are Delegate Vaughn Stewart's House Bill 71 and 197. Then we have House Bill 91, Delegate Holmes. Then some guy named Barve has 157. And then the final bill of the afternoon will be Delegate Ampry, House Bill 179. So Delegate Stewart, you have the floor. The timer is up there. We're trying something different because apparently people were distracted by the unbelievably GQ handsome Ben Jabin. They didn't notice the timer near his head. Somehow they were captivated only by the appearance of Ben Jabin. So we've decided, it's a burden he has to live with. So we have the timer there, and like with the old TV show Love Connection, Vaughn, you've got 2 and 2, so 4 minutes total. Go.
Thank you, Mr. Chairman. That was actually me, Ben. It was your very manicured beard that did the trick for me. So I apologize for that. So for the record, I'm Delegate Vaughn Stewart. This is House Bill 71. Manufactured homes, modular homes, and mobile homes are a great affordable housing option for Marylanders. These homes are much less costly to build. They often look identical to site-built homes, and they can be sold much more affordably. But one impediment to the growth of this housing option is the vulnerability of residents who own a manufactured or modular or mobile home, but they live in a community where they lease the land underneath the home. And these folks, I was surprised to learn, are actually more vulnerable than Marylanders in almost any other type of housing. They're working class. Their most important investment is basically at the whim of the community owner. They're more tethered in place than any other Marylander because it costs as much as $20,000 to move a home from one community to another. And that's only if there's a vacancy in a nearby community. And then finally, these Marylanders receive less notice before they might have to leave the community than basically any other person in Maryland. And that's what House Bill 71 is about. So House Bill 71 requires that when a manufactured home community or a mobile home community is going to be sold, that the current owner of the land must notify the residents, the homeowners, of the sale 60 days before the contract is signed, before the offer is accepted. And that time window gives residents more notice, and it also perhaps gives them a chance to put in an offer to purchase the communities themselves. Many of these so-called resident-owned communities have been successful around the country, but obviously there are obstacles there for residents who do want to purchase their community to get financing and to organize so quickly. And so even if this bill results in 0 resident-owned communities, that extra notice provision is extremely important because under current law, residents in these communities only get 30 days notice before a sale is completed. So they only have 1 month notice to research the cost of moving their home or to find vacancies in other communities or to simply sell their home because they can't move it, or 1 month notice perhaps before a hedge fund, as has become common, buys the property and jacks up the rent. So 1 month notice only before their investment and perhaps their lives, might be completely turned upside down. And no other Marylander is subject to so little notice. Evictions of traditional renters, as we know, take at least 4, 5, 6 months to complete. The foreclosure process often takes longer, and unhoused folks are granted sufficient notice and due process if they're asked to leave a shelter. Maryland is sadly leagues behind our neighbors on protections for these residents. We're the only state between Virginia and Maine without any protections for residents in a manufactured home community when it's sold. And so in conclusion, I've spoken with the opponents. I appreciate their input, and I've submitted a sponsor amendment that addresses all 100% of their stated concerns, good faith stated concerns, with the initial version of the bill. For example, we have shortened the notice period, we've altered the penalty provision, and we've removed a real property conversion provision that the bankers didn't like. So I think Bob Inton and I are once again, for the second time in this session, in accord on this bill. And the amended bill is actually based on Virginia's notice law. And that's important because companies like Horizon Land Company that you'll hear from later already own several thriving communities in Virginia. So they're already complying with basically the version of the law that's before you today. In conclusion, HB 71 will treat residents more fairly and make modular, manufactured, and mobile homes a more viable solution to our affordable housing crisis in Maryland. I urge a favorable report.
Well, Delegate Stewart, you will rue the day that you said it takes 5 months to evict a renter. Did you hear that, Bob? Were you recording that? No, anyway. Okay, well, I'm going to go to all the proponents, and then we will entertain questions, and then we'll go to the opponents. So first, Marceline White with the Consumer Protection Division, the Consumer Rights Coalition. Marceline, I'm not sure if I see, oh, there you are. Yeah, you've got 2 minutes. Welcome back to the committee.
Thank you so much, Chair. Good afternoon, Chair, members of the committee. For the record, my name is Marceline White. I'm the Executive Director of the Maryland Consumer Rights Coalition, and we work on economic rights and equity through research, education, advocacy, and direct service. We are here in strong support of HB 71, and I want to thank Delegate Stewart for sponsoring the bill. We support this bill for 2 critical reasons. One, it will help to preserve affordable housing in Maryland, and 2, it extends and expands important consumer protection notice and transparency issues. In 2020, DHCD noted there's a massive lack of affordable housing and affordable units for working families in Maryland. Manufactured housing is one option for affordable housing. There are about 36,000 residents of manufactured housing in Maryland today. They pay lower rents and have lower incomes than traditional renters and traditional homeowners. So they are an important last bastion for affordable housing in our state. These units are also customizable. So if you have disabilities or are looking for green footprints, these are good options for you as well. As Delegate Stewart mentioned, there's an issue of notice. If someone's going to sell the park and develop the land or sell it to a private equity firm, which we've seen happen across the country, at which point rents and fees are jacked up between 40 to 60%. What this does is provides notice so people can either look to exit the park in a dignified way and accumulate funding to do so because it's expensive, or make a bid and the seller will have to entertain the bid from the community. And you'll hear from others about successful communities all over the country that have done this. So it provides several different options. Most importantly, the notice and the opportunity for people to put together a bid or exit with dignity. So for all these reasons, we support HB 71 and ask for a favorable report. Thank you.
Thank you very much. Next, we're going to turn to Doug Ryan with Prosperity Now. Doug?
Yeah, great. Thank you. Thank you, Chairman Barve, and thank you, Delegate Stewart, for introducing this piece of legislation. It's very important to us. My name is Doug Ryan. I'm the Vice President for Policy and Applied Research at Prosperity Now. We are a nonprofit intermediary based in Washington, D.C., who works on issues of great import to low and moderate income families and families of color in order to improve financial well-being and financial stability. I also want to add that I'm a longtime housing advocate, a resident of District 16. Great to see Delegate Love here, and I appreciate that. And also, I have worked in this space in Maryland for some time, including 13 years at the Housing Opportunities Commission. We've worked in this space for about 16, 17 years, and we have seen the value of resident-owned communities. It's extraordinarily important. I added some more detail in my written comments, but I want to highlight a few things. First of all, the goal of state housing policy anywhere should really be to house the most people at the lowest cost, and preventing displacement and preserving housing is key to that strategy. So I encourage the state to continue to look at efforts to do that, including adopting HB 71. It's extraordinarily important for families' housing stability and long-term financial well-being. Second, we've seen from the pandemic how important housing stability is, and families, as Delegate Stewart noted, who live in manufactured housing communities or mobile home parks are at the most risk of displacement than any other family or in any other type of tenure in Maryland and indeed across the country. Second, I would also note the value of resident ownership. These communities across the country in states like New Hampshire, Massachusetts, Oregon, Washington, Minnesota, and elsewhere have demonstrated that they provide affordable housing at a lower cost to the family, added stability, lower operating costs, and also a better return when they choose to sell their homes because of lower cost financing. The advantages are immeasurable, and I encourage a favorable report. Thank you again for your time this afternoon.
Thank you, sir. Next, let's go to Maryland Legal Aid, and I assume that's going to be Greg Countess. Greg, welcome back. You're muted.
Well, that gets me to do a do-over. So thank you very much, Mr. Chair and members of the committee. I'd like to thank Delegate Stewart for introducing this bill and also for inviting Maryland Legal Aid to testify. As you know, Maryland Legal Aid is a statewide law firm that represents those folks who cannot afford an attorney. We handle a number of cases in a number of different subject areas, whether it be public benefits, housing, of course, as well as domestic and family law, as well as children in need of assistance, and we help people out with expungements. First of all, I would just like to say that Delegate Stewart just simply made all of my points as did the prior folks testifying. So let me just add this. I would echo the points that he made, except for the 4 to 5 months to get someone evicted. I don't know what eviction Delegate Stewart is referring to, but however, anybody can tell you that the sale of a rental property disrupts the lives of both the renter and the family, and it's high time that mobile home park owners who reside in mobile home parks have the opportunity to be able to lessen this disruption by banding together with their neighbors and being able to purchase their homes. And this is only fair, I would think. Almost 40 years ago, Maryland enacted a statute that allows subsidized housing tenants, if certain actions are taken, to be able to purchase the apartment complex where they reside. I've had a number of clients who have attempted to navigate that particular process. It wasn't always successful, but it provided them with some protection in terms of giving them time to find some place to move or even to put together a deal. So I see that I'm out of time right now. So I'll end this to simply say that we ask that there be a favorable report on this bill. It's really important for low-income Maryland families because mobile home parks are affordable housing. Thank you very much.
Thank you so much. Next, let's turn to Jonathan Rydell with CASA. Jonathan, welcome to the committee.
Thank you, Chairman Barney. Good afternoon, everybody. My name is Jonathan Riedel. I'm a supervising attorney at CASA. CASA is pleased to provide our support for HB 71, the Manufactured Homes Modernization Act. CASA is the largest membership-based immigrant rights organization in the Mid-Atlantic, with more than 90,000 members in Maryland. CASA supports this bill because we have many members who reside in manufactured homes, otherwise known as mobile homes, especially in mobile home parks. As you all know, mobile home owners don't typically own the land on which their house sits, but they own the structure atop it and all the fixtures inside, the plumbing, the electrical, appliances, furniture, and so on. And the landowner typically rents out the plot of land to a mobile home owner and charges a fee for placing the home atop it. About our members, CASA's mobile home owning members are primarily low-income immigrants. They have been excluded from traditional home ownership because of their income and immigration status. And so the mobile homes they've purchased often represent the most significant investment of their lives, and losing it or even having to move it is often catastrophic because those are linked in many ways. So with this bill, our members have the opportunity to stay in their homes and redeem their investments. As you can imagine, moving a home of this size is extraordinarily difficult and expensive. It's unlike the typical rental of an apartment. If a landowner decides to raise the price of rent, in this case, it costs them thousands of dollars to move every shower, toilet, sink, bedroom wall. Every nut and bolt has to be carried out and moved to another plot of land. So this often it entails leaving an entire community behind with very little recourse. So this bill gives a small opportunity to avoid such tragedy. It's a market-based solution because the landowner does not have to, they have the right to decline an offer from a tenant. It's not a regulatory solution, it's really market-based. So it should be a win-win for all sides, for landowners and mobile home owners. And we think it's an easy, cheap way to enhance and preserve affordable housing in Maryland. So for that reason, we urge a favorable report.
Thank you very much. Let's now go to Andrew Pizer, who is signed up favorable with amendments, and then we'll round out this with Bob Enton, who's also signed up favorable with amendments. So Andrew, welcome to the committee. You have 2 minutes.
Thank you, members of the committee. I appreciate the opportunity to testify on HB 71. My name is Andrew Pizer. I live in Charles County, and I'm an attorney at the National Consumer Law Center. NCLC is a nonprofit specializing in consumer issues, particularly those affecting low income and the elderly. We've long had a focus on manufactured housing. As has been mentioned, it's the largest source of unsubsidized affordable housing in the country. This bill would be a great step forward in stabilizing and improving manufactured home communities in Maryland and the lives of the people who live in them. The bill would accomplish 2 very important goals. First, it would give residents the chance to purchase their communities. Now, similar laws in other states have had a tremendous impact. New Hampshire, for example, has preserved over 8,000 homes as affordable housing. When residents own a manufactured home community, they invest in it. They repave the roads, they fix the sewers, they add landscaping and amenities. This benefits the community at large. Being able to make decisions collectively about the park increases civil engagement, and that reduces societal conflict. This bill has all the features necessary to accomplish this in Maryland, too. Second, this bill gives manufactured homeowners greater ability to title their homes as real property. I don't think other witnesses have touched on this. Maryland currently prohibits many owners from doing so, instead leaving their homes classified as personal property, like a car or a television. Expanding the ability to convert manufactured homes from personal to real property would have many benefits. It would allow those who live in manufactured homes to enjoy the rights and protections available to those living in site-built homes. It would open more homes, more opportunity for financing, better financing, lower cost. It would integrate manufactured housing into the mainstream housing market and protect the rights of secured creditors as well. For all these reasons, we urge the committee to vote favorably on HB 71, and I thank you for allowing me to testify.
Mr. Chairman, you are muted.
Sorry, did you mention what your amendment was? Maybe I was distracted and I didn't hear that.
Me? Yeah, so I have a pretty substantial amendment that does, I mentioned it very briefly, but essentially.
Oh, all right, okay, well then we'll get to that
Okay.
after we hear from Bob Enton then.
Okay.
Okay, Bob Enton with the bankers. So you've got 2 minutes, take it away.
Thank you very much, Mr. Chairman. Robert Enton on behalf of the Maryland Bankers Association. We are signed up favorable with amendments. We met with the bill sponsor, and the bill sponsor, I believe, has an amendment which he's offered or will offer to the bill to strike the provisions regarding conversion. It leaves in place the provisions dealing with the right of first refusal. It's difficult for me as an attorney to just understand how someone who has no ownership in a piece of land can go ahead and convert that into ownership because they have basically a lease on that property. So we had a lot of questions about how that would work, how that could possibly be financed, how would title insurance be issued, all those issues. And I think that, something that would require a pretty fair amount of study. We expressed those concerns to the sponsor, and the sponsor sent me an amendment, which we were fine with, which took that part of the bill out and limited the bill to the right of first refusal. And on behalf of the banking industry, we don't have any problem with that. So if the sponsor's amendment is adopted, which I hope it will be, then we have no problems whatsoever with the bill. Be happy to answer any questions.
Okay, thank you very much. It looks like the first hand up is, let me just double check to make sure. Delegate Clark.
Thank you, Mr. Chair. Delegate, just one very quick question. If you have an owner of a park that sort of has a hybrid model where he actually ground leases the pad and also owns the pre-manufactured home on the property himself, does this bill do anything to change his rights or abilities right now to regulate his rental home or rental?
No, that's a great question. That's a great question, Delegate Clark. My understanding is the definition of a manufactured or mobile home community within the bill clarifies that you're talking about communities where you have a ground lease, but where the residents do own the property over the land. So the type of community you're describing where the residents would both lease the land and lease the homes would not fall under the bill.
Okay, thank you.
Delegate, I've got a question because I just want to be absolutely certain I understand the mechanics of what's happening here.
Yes.
Let's say I have a mobile home and I am paying to you, the owner of the land. I'm just going to make up a number, $400 a month. I have no idea. I have no idea if that's a typical, but let's say I'm paying you $400 a month of some amount. That doesn't really matter. And you go and a private equity firm says, I want to buy all of your land and I'm willing to buy the part that Kumar's house is on top of. I'm willing to give you $4,000 for that. Is it your intention to give me how many days notice?
60
days notice. And if I'm able to come up with more money than what you're getting from the private equity, I and my neighbors are willing to come up with more money than what the private equity firm is offering you, do we then have the right to purchase it? Or how does that work?
Not quite. Very close. If there is a homeowners association already in existence that can prove that a majority of the residents, and not like sublease or something, but actual residents on the lease, more than half of them are a member of a homeownership association, you provide that verification, then within that 60-day window, but for no other future amount of time, they can submit an offer. And what the bill says is that in your example, I'm now the landowner. If you and your neighbors, as part of a homeowners association with a majority, submit an offer to me, all the bill says is that I have to consider it. You have no right to purchase. I just have to consider your offer. And so as we've talked about already, this may not yield a ton of resident-owned communities. I think resident-owned communities are good, but we may not get a whole lot of them. There are barriers. And that's why one thing I really tried to highlight is that the notice provision alone, even if you and your neighbors, Chairman Barve, didn't actually ever put in any home community in the state, ever actually put an offer together, I think making sure that folks have 60 days notice is really, really important.
Okay, so the next question I have is, let's say for the sake of argument, I have a mobile home, but I'm subleasing it to somebody because I'm away in Annapolis for 3 months. So I'm still the person that's a member of the community association. I'm the one who has the vote, correct?
Correct. Yeah. If you're subleasing it, they get no rights under this. It has to be a homeownership association where 51% of the membership is made up of actual owners of the home and original lessees.
Okay. Delegate Wyville has a question.
Yes, Chairman. So does this apply to to Delegate Stewart, does this apply to any size manufactured home community, whether it's one, or do you have a certain minimum?
I think that the definition of manufactured home community may already exist under statute, and there might be some sort. I think that there is some sort of minimum number of homes in a community so that it's a community. Our intent would certainly not for it to apply to a single person, and if that's not already part of the law, I would obviously be happy to entertain an amendment to put some sort of minimum number of homes so that we're all talking about the same thing here.
Yeah, I just wasn't clear and I couldn't find it in the bill because we're in a rural area, obviously, and we have folks that may lease a 1 acre parcel of property, put a manufactured home on it. So I didn't know what the threshold was. I appreciate you if you could clarify that. So as amended, it's my understanding all the bill does is the right of first refusal and gives a 60-day notice.
That's basically correct. And yeah, and thanks for the opportunity to point it out that even though I agree with Andrew from NCLC wholeheartedly that this real property title conversion piece is really important, I do also agree, maybe for the first time ever with Mr. Enton, that I think we need to go back a little bit more to the drawing board and study that for future sessions. So that piece has actually been removed in the sponsor amendment. And all the other objections from the opponents that you might have read in their written testimony, every single one of those are addressed, because now all the bill does is basically provide a 60-day window with a lesser penalty provision, so that folks have a little bit of notice before their lives are potentially derailed.
Okay, thank you.
I can now die. I've heard Vaughn Stewart talk about 5 months to evict people and him agreeing wholeheartedly with Robert Enton. I have nothing left to accomplish in life. Okay. Okay. Any other questions for the proponents of the bill? Seeing none, let's turn to the opponents, and they are Camille Fesh and Matthew Bole. I believe that's how you pronounce his name. But Camille, welcome to the committee, if you're there.
Thank you very much, Mr. Chairman, Mr. Vice Chairman, and members of the committee. For the record, my name is Camille Fesh with RWL Law, and we're here, Matt and I are here on behalf of Horizon Land Company in opposition to HB 71 as drafted and submitted. We submitted our written testimony, which addressed the original drafting of the bill. We do want to thank the sponsor for, we appreciate the amendments that he's put in. We appreciate him listening to us. However, it was a 12-page bill, and we've got 2 pages of amendments offered that strike approximately 9 pages of the bill. So we're still digesting these amendments and their ramifications. So at this time, we are putting in our opposition. And we still have some remaining concerns. First off, in Maryland law, there is no prohibition on residents purchasing the community in which they live at any time. Anytime, they don't have to wait for a sale to happen. Today, a number of residents or owners of manufactured housing units in a community could band together, could come up with an offer, and could approach the owner of the park or owner of the community. So I do want to make that clear that there's no prohibition on residents and owners of manufactured housing units purchasing their communities. Some of our specific concerns within the bill I saw some of the questions that were just asked. Who exactly is part of the homeowners association? Is it the homeowners themselves? Is it people that are leasing from owners? So is it owners and the residents? And who exactly 51%, what exactly does that mean? This is not clear defined based on our quick review of the amendments. We've only had, my goodness, I guess, a day or so to take a look at this. Second issue would be what constitutes willfully in terms of penalty provisions. Also, the penalty has been chopped down from $50,000 to $10,000, but could also be 50% of the gain realized by the sale. That is an onerous penalty, and that actually would really harm the viability of manufactured housing communities. So we believe that this bill, given its substantial revisions, still needs substantial work and more careful consideration to be specific in policy matters. Our client is dedicated to creating and preserving thriving communities and defending the viability of manufactured housing communities. So it's we are going to oppose anything that will hurt the viability and hurt the ability of owners to.
But they do get processed and canvassed, just
Okay,
like every other.
Somebody needs to mute themselves. Okay. Next, we're going to hear from Matt. Matt, how do you pronounce your last name? I forget from one year to the next.
Don't worry, I've gotten worse before. It's Boley, B-O-H-L-E, Boley.
Okay.
Thank you, Mr. Chair. Good afternoon, and Vice Chair and members of the committee. I'm Matthew Boley of RWL Law. I had remarks prepared for today on the bill as introduced, but due to the amendments and the comments from my colleague, Camille Fesh, I have no further comment at this time and will gladly yield my time back to the committee.
Okay. Camille, let me just add, so basically, even though there have been substantial amendments to the bill, your group just has a fundamental problem with the fundamental premise of the bill. Really, there's no amendment that really could cause you to get on board, correct?
I would always hate to say that because we always do want to work with bill sponsors.
Sure. No,
but we do feel that there are some serious issues that will hurt the ability. And when properties are sold, when communities are sold, they're not necessarily, they may be sold from owner to owner with the intention of maintaining the property and running the park. When a property is sold, that doesn't mean it's automatically going to a hedge fund, and it may, but it does not mean it's automatically going to a hedge fund backed entity, or means that the new owner has an interest in destroying the community and turning it into something different. So not because a park is being sold does not mean that residents will have to move or be evicted from the site at all, or that rents will be substantially increased. That may happen, but that is not a guarantee.
Okay. So I guess the answer is yes. Okay. Any questions for the opponents? Well, seeing none, then that means we'll conclude the public hearing on House Bill 71. We will proceed, and thank you everybody for testifying. We'll proceed to House Bill 197. Again, Delegate Stewart.
And again, thank you, Mr. Chairman. For the record, I'm Delegate Von Stewart. This is House Bill 197. So this bill is a companion bill to a bill we heard last week, and it basically aligns the law with respect to insurance deductibles for co-op buildings with the law with respect to insurance deductibles in condo buildings. The bill establishes a $10,000 deductible cap for a co-op member when the cause of loss originates in their unit. This is in line with House Bill 108, which the Vice Chair sponsored in 2020, which sets a $10,000 cap for condos. And the intent is basically to prevent individual members in co-ops from being crushed with a multi-million-dollar claim for damages that isn't necessarily their fault. I really appreciate CAI, again, for taking so much time with me to thoughtfully consider amendments to the bill to make it workable. Mr. Silverman is going to discuss those considerations in more detail, but here's basically the major one we have to think about. So for condos, the major insurance carriers offer policies called HO6 policies. But there are no analogous policies specifically designed for co-op members. Our understanding is that the major insurance carriers will and do provide these HO6 policies to co-op members, but we might need to amend the bill to make the deductible cap contingent on the availability of those policies. Because what we don't want to do is inadvertently pass a bill that puts co-op members on the hook for $10,000 when there's no way for them to obtain insurance. So I believe you're going to again hear from my constituent, Ms. Katzman, about this, and then you're going to hear from Mr. Silverman from CAI to provide more information about how we can align the law in co-ops to the law for the condo universe. And I urge a favorable report with amendments that are forthcoming from CAI.
Okay, thank you very much. Let's go to the witnesses who are in favor. And unlike the last bill, no one is signed in opposition. So let's go to S. Katzman. You are on, Ms. Katzman. And you need to unmute yourself, ma'am.
Thank you.
There you go. There you go.
Thank you, sir. And thank you to the committee. Delegate Stewart, thank you for introducing this and the companion bill as had been requested. And I do want to clarify that in fact, insurance companies do sell HO6 to co-op members. At the time that this was passed by my co-op, as an example, I had to switch from a renter's policy, which covered me because as a co-op member, you do not own the co-op, you pay your money and you become an occupant. You retain occupancy as per an agreement as a shareholder. So in fact, HO6 is the policy that can be obtained from any insurance company for a co-op member. And also to clarify, this should be in your amendment specified that it's only when it is deemed by the insurance company to be a fault or negligence or misuse by the co-op member that the deductible would be in place. It's absolutely necessary that this bill pass in that we are experiencing, as an example, a $50,000 deductible here in Leisure World in the 897 unit co-op known as Montgomery Mutual. Unlike all the rest of the mutuals in Leisure World, by example, which are condos, and they are capped at 10,000. So it's only equitable that the co-op law come into the same level of compliance as the condo law. I thank you for your time. I hope that this will pass with the amendments. Thank you.
Thank you. And let's turn now to Scott Silverman with the CAI. Scott, welcome back to the committee.
Thank you very much, Chairman Barbe and Vice Chairman and members of the committee. I am speaking on behalf of the Maryland Legislative Action Committee of the Community Associations Institute, CAI, to voice support with amendments for the proposed legislation. As I've discussed previously with Delegate Stewart, CAI is concerned about a couple aspects of the law. As he said, it is intended to bring cooperatives in line with condominiums. However, and this differs a little bit from Ms. Katzman's testimony, I want to disagree with her a little. It's critical to us that the law be written so that negligence or fault of the member not be an issue with respect to responsibility for the deductible. And the reason is that years ago, before the Condo Act was amended, there was substantial amount of discussion and debate and litigation over negligence and whether a condo member could be charged with the deductible under the master policy was governed by principles of negligence. That took us down a rabbit hole that resulted in very disparate impact on citizens of Maryland that lived in condos. And when the Condo Act was revised, it was revised to essentially provide for no fault insurance. In other words, if the cause of loss originates in a unit, then the deductible can be charged back. We are very concerned that that be the case with regard to co-ops as well. However, one of the things that we need to ensure is that the co-op carriers, the carriers of HO6 policies, agree to cover the deductible up to $10,000, which they had to do as a condition under the Condo Act revisions several years ago.
Okay, thank you very much. We have a question from the Vice Chair.
Thank you very much, Mr. Chairman. For Delegate Stewart, is current law the same as it was before our bill a couple years ago, that the maximum deductible is $5,000 and you want to increase that to $10,000?
No, and thank you for thank you for letting me clarify that. So actually in the co-op world, there actually is no cap whatsoever. So I know y'all's bill increased the cap 5 to 10,000, which made sense, I think, and that's why we basically all voted for it, to adjust that law for inflation. I think that was, very fair to the condos. However, no cap whatsoever exists in the co-op world. So that's essentially the reason for the bill.
Okay. And also one thing we did a couple years ago was we specified that a casualty event is a common expense if the cause of damage to the condo originates from outside the unit or in common elements. Is that something that you do as well?
Yeah, Mr. Silverman is vigorously nodding his head, so I guess I'll defer to him on that.
Yeah, yes, Delegate Stein, I just wanted to point out that I agree with Delegate Stewart that not only is there no cap with regard to co-ops, there's no authorizing legislation to allow the chargeback to occur in the first place. That's what this is intended to do, is to allow the co-op to recover its deductible if the cause of loss originates in a unit. Now, although co-op members do not own their units, the unit is a defined term in the Cooperative Housing Act. It is defined as that physical space that is occupied by the member versus as owned by the member in the condo world. So there is already a statutory definition for unit. We're simply trying to bring the cooperative members in line with their condo neighbors. This is particularly an issue at Leisure World because you have both co-ops and condos living side by side there. So that is the intent. But as I think Delegate Stewart pointed out, and possibly Ms. Katzman also, one of the conditions of the Attorney General's support for the changes in the Condo Act, you may recall, was that the HO6 carriers were okay with going from 5,000 to 10,000, and they would provide condo owners with that coverage. We definitely want that to be a condition here as well, because we don't want to create a situation where we've authorized the co-op to charge one of their members $10,000 and then have that member not be able to obtain coverage for the $10,000 assessment. So we want to make sure that the carriers are on board with this in the co-op world as well.
Okay, and just to confirm that if the damage originates from outside the unit that a member lives in, it's clear that the family that lives in that unit is not responsible beyond the $10,000, or it's not responsible at all.
They would not be responsible at all. You are correct. It would be a common expense.
Yeah. Okay. Thank you.
All righty then. Any other questions? There appear to be no further questions. So that concludes the public hearing on House Bill 197. We'll proceed to House Bill 91. Delegate Holmes looks like a switchboard operator or an air traffic controller or something. Nice get up there, brother.
Thank you, Mr. Chair. I've had the necessity to wear the headphones and the microphone because of some outside interfering noise. I didn't want to conflict. But thank you, Mr. Chair, for allowing me to present to you this afternoon HB 91. And I think, Mr. Chair, because we have new members on our committee, I think I need to start by establishing how and why and the origins of ground rules. We all know that back in multiple centuries ago, if you wanted to build a castle, you could build your castle, but the king still owned the land. And Mr. Chair?
Yes.
I can feel, Mr. Chair, you have a question. I can feel, Mr. Chair, I can feel you have a question. Mr. Chair, the answer to your question is Summer of 1634 by King Charles I. That's the answer to your question, Mr. Chair.
How did you know? How did you know?
Mr. Chair, I knew that was the answer to your question. Now, the question that everyone wants to ask is, when were ground rules established? Thank you for asking that question, Mr. Chairman. I appreciate that. So, Mr. Chair and members of the committee, this bill is an attempt to establish or reestablish the differences between two types of ground rents. There are the redeemable ground rents and the irredeemable ground rents. Now, let's go back to the scenario of the king and the land.
It's kind of like redeemable delegates and irredeemable delegates, isn't it?
Absolutely correct.
Okay.
So going back to the scenario of the king and the land, if you had a redeemable ground rent, that means that if you financed or purchased a castle, or if you purchased a castle or refinanced that castle, you could redeem that ground rent from the king, and now you could own the land and the castle. An irredeemable ground rent, however, Mr. Chair, means that the king has already signed a piece of paper that says they will never, ever, ever redeem the ground rent to the castle owner. Now, Mr. Chair, I can feel a question, Mr. Chair. I can feel it, Mr. Chair. I can feel it. Oh, hang on a second, Mr. Chair. The answer to your question, Mr. Chair, is Hawaii. The answer is Hawaii, Mr. Chair. The question is, what only other state in the United States has ground rents? Hawaii. So you can see, ladies and gentlemen, how out of date this whole ground rent scenario is. Now, back in 2010, Mr. Chair, the legislature not back in the 1600s, but 2010, the legislature put in a legislation to say that if you had an irredeemable ground rent, you have to have the documents filed with SDET. That way, the castle owner knew that they had no opportunity at all to purchase that ground underneath them. So, Mr. Chair, I can feel something here, Mr. Chair. I can feel it.
Oh, no.
I can feel, Mr. Chair. The answer to your question, Mr. Chair, is 12. 12, Mr. Chair, 12. Your question to me, Mr. Chair, was
how many seconds do you have left?
how many irredeemable ground rents are there in the state of Maryland? 12. So you can see, Mr. Chair, that we are attempting to get something taken care of where if you have one of those irredeemable ground rents, you don't have to hire an attorney to figure out how to get this done. And Mr. Chair, I feel something else here again. I can feel it. Mr. Chair, the answer is yes. Mr. Chair, the answer to your question is yes. Question, Mr. Chair, was, does this include my testimony on HB 91? Thank you, Mr. Chair.
Delegate Foley and Prettyman, you have just been subjected to an annual behavior pattern on the part of Delegate Marvin Holmes. Trust me, after 4 or 5 years, you'll get used to it. Any questions for the chairman of the Real Property Subcommittee? No? Okay, well, we're done then. Off to your subcommittee you go. Okay, the next bill is House Bill 157 by some guy named Kumar Barve. And I get 4 minutes, just like everybody else, by the way. My wife and I move down to Annapolis every year, and she likes to work out at the Pip Moyer Center. And they have 2 electric car charging spots there, and there's always a gasoline car parked in it. She's never once, not once, has she charged her electric car at the Pip Moyer Center. And she went and complained to the people who work there, and they said, well, you know, ma'am, there's nothing we can do because it's not illegal, and we just don't feel that we can do anything about this. And so hence House Bill 157, and it's pretty simple. It basically establishes in the law the fact that if you have a non-electric vehicle and you don't obviously don't have it plugged in, you can have a civil citation of $100, and if the private owner, that is the person who owns the parking lot or the building, can have you towed. And this is really not so different from the way we handle handicap parking spaces. A person with a conscience would park in such a spot because it's convenient. And the fact of the matter is we have to transition to electric vehicles. And this is a very small price to pay to make it possible for people to charge up their cars when they go to the grocery store, when they go to places like the Pip Moyer Center in Annapolis and elsewhere. And so this is a bill that's passed this committee before, I think twice, maybe only once, but it got hung up on the last day of session in a filibuster. And so I would ask for you, my colleagues on this committee, to pass it again so that we can get this bill hopefully passed into law. The cross-file is Ron Young, who has a very similar bill. It's going to be amended to be identical to the way the bill is here. The bill is right now in the same state in which it left the committee in the House of Delegates last year. That's it. I ask for you to move favorable. Let's see if there are some people signed up in favor of the bill. What a novelty. Andrew Frazier is signed up in favor of the bill. Andrew, welcome to the committee. You have 2 minutes.
Oh, thank you, Delegate Barve, and thank you for putting this bill in. I think it's an excellent idea. And I will say that I agree with you on the need to go electric. Companies who actually invest the money to install one of these chargers, they're not yet making a lot of money on their investment. And for someone to take that opportunity for them to make money after they've paid all this money to install that infrastructure is just, I mean, it's just taking money out of their hands, and they're not making money yet. So that on the commercial side, I think that's really important that, you know, that they are allowed to make that money. On the other side, I would say preventing people from charging by parking a gas car in these spots is just works totally against the whole effort that we're trying to do. If you bought an electric car and you run into this experience and then you go and tell other people, oh yeah, I couldn't charge because someone blocked me, it's just not good for us. I think this is just a horrible idea. I think the bill is an excellent idea. And I really like the idea of aligning it with parking and a disabled. And I think you should align with the fees as well. I would almost go as far as saying if you do have an electric car and you let it sit there for a couple hours and you're not charging, that you should also be fined. But I think that's a little too far right now. But I do think it's important. I totally feel what you're saying about not being able to charge based on you know, someone in a gas car blocking the space. It's rude. It's wrong. And I'm very much in favor. I think it's a great idea. Thank you very much for allowing me to speak today.
You know, you bear a resemblance to somebody I know. Could you be related to someone?
Don't know the guy.
Okay. All right. Okay. Next, we have Lanny Hartman, who signed up favorable with amendments. Lanny, welcome to the Environment and Transportation Committee.
Thank you, Mr. Chairman. My name is Lanny Hartman, and this bill would penalize an electric vehicle driver who is not connected to the charging equipment, the same as it would penalize someone who is blocking the charging station with a gas car. My concern with that is that there's no way for the enforcement authority to tell for certain that that electric car driver never intended to charge in the first place. For example, we have had our car unplugged while it was sat unattended in a garage before. Another example is that one time I went to a Royal Farm store that had a charging station, and it turned out that the charging station was broken. And after trying to get it to work for a few minutes, that it then stopped. I stopped to go into the store, and I got halfway walking to the store and looked back, and my car was sitting there unplugged. That would technically leave me vulnerable to a fine, especially if the fines are going to be as high as for ADA parking spot violations. That could be as much as $500. So that's my concern. I hope you will consider an amendment to strike that and bring it into line with many other states that just focus this on gas cars. And there are 4 counties in Maryland, Montgomery, Howard, Baltimore County, and most recently Frederick County have passed an ordinance, and none of them apply to and get into complexities of applying to an electric car that's not plugged in. They just focus on gas cars. Thank you very much.
Okay, thank you. By the way, the maximum fine in this bill is $100. So, okay, we have a question from Delegate Boyce. Delegate Boyce.
Thank you, Mr. Chairman. I just want to be clear about the last testimony. You're stating that you should be allowed to park in a plug-in required to essentially rejuice your car, even if you're not rejuicing your car.
Not exactly. It seems like a simple bill. We want to keep anybody from blocking those spots. However, there are just no way for an enforcement authority to be able to tell that somebody didn't come along and unplug the car, which has happened to us before.
The section would be open where it was plugged and something would be on the ground, correct?
Not necessarily. The last time it happened to my wife in a garage in Baltimore City, the dash cam in the car showed that the person unplugged it and put it back into the holster. There would have been really, there can be no evidence that of what happened to someone coming up to the car.
Fair enough. It just sounded like you were also making the assumption that because it's a plug-in and you have an electric car, that you could park there even if you're not charging. And I think if it's meant to be charged, then you shouldn't be able to park there if the car is then charged.
Yeah, I understand exactly what you're
Okay.
saying. This is not about privileged parking. And a lot of people that don't drive electric cars might look at this like, well, we can't let people that drive Teslas just park at the spot up front near the front door where the charging station is and not even plug in. And I think a lot of people think that because that's where they see the electric vehicle charging stations, and that is where a lot of the first charging stations were installed, where nowadays the charging stations are more likely to be in the back of the parking lot. Also, Tesla, in many cases, allows gas cars to park in the charging stations for a period of time, like at the Sheetz or a Wawa. Half the stations will say Tesla vehicle charging only. The other half will say something like 10-minute general parking, because the Sheetz wants that flexibility to allow people to occupy the spots while they run in and get something and come back out. So it just requires some flexibility. Mm-hmm.
Yeah, let me just say that the only way the enforcement would occur is if the property owner called the police and complained about it. The property owner would have to lodge a complaint. And okay, any further questions on this bill? There are no opponents, which I would like to see.
For some reason, I can't get my hand.
Okay, go for it, Delegate Ampry.
My question is, so the bill will require the owner of the property where the illegal parking is taking place to call the police. Is that?
No, it doesn't require that. I'm saying as a matter of practicality, that's the way it would be, because the police are generally busy doing more important things.
Right. Okay. So, I'm just wondering if only parking enforcement can be the body that's called, like, asked to come handle this. I don't know if I guess something we can talk about offline. I'm just wondering.
Yeah. Okay. I mean, I'm not sure I understand the question, but yeah, absolutely.
Yeah. What I'm worried about is just the concern is that if people are parking in these spots and don't necessarily are as knowledgeable, we're adding police to come deal with something that's not necessarily just reducing. I think we're in a world now we want to reduce police interaction. I think that there's something in the bill that can state that the reliance of people.
The bill requires signage for these parking spaces. And as a general rule, what would really probably happen is the parking lot owner would call the police and the police would write a ticket. Now, the parking lot owner could, if he or she wanted to, tow the vehicle. They could certainly do that. Under this bill, they could. But for the most part, I think the police are going to be, busy doing other stuff. And for them, it'll just be a ticket that they'll stick on the car, I would think. Delegate Lehman has a question.
I'll have to turn this into a question because it's probably more of a statement, but I believe it's the case that in some jurisdictions, I know for certain Prince George's, that it's civilian agencies that enforce parking. In Prince George's County, it's called the Revenue Authority. And you wouldn't be involving the police at all, but it would be complaint driven. Is that how you envision it, Chair Barbie? Typically laws like this are complaint driven. Would be, I assume, somebody coming along like me in a hybrid or you in an electric car, really needing to charge and seeing that there's a gasoline, powered car taking up a space that you could have benefited from.
Yep, that's my intent.
Thank you.
Any further questions? Okay, seeing none, thank you very much. That concludes the public hearing on House Bill 157. We will go to the last bill of the afternoon, House Bill 179. Delegate Ampry, you've got 4 minutes.
Thank you so much, Mr. Chair, and my esteemed colleagues. I'll be speaking on House Bill 179 today. It was brought forward last year as House Bill 1325, Legislative Food Environment Reports. It's being introduced for the purpose of requiring the Department of Housing and Community Development and the Department of Planning to produce a report for each state legislative district on the food environment in the district. The reports will include detailed metrics that identify healthy food priority areas, formerly known as food deserts, or the term that we often use when we're describing areas that don't have adequate access to fresh foods. And we'll calculate the Healthy Food Availability Index, the HFAI, in each district. And last year we brought this bill forward, and I felt as though many of you agreed that this was a great idea and that we need these types of programs in order to ensure that we are thinking through how to best bring fresh foods into communities that are in desperate need. One of the reasons that I bring this bill forward today, or one thing I want to make everyone to just think about for a second is, over the past 2 or 3 weeks, we've seen a issue with access to fresh food in every neighborhood across most of the state, given that shipping was a difficulty for many industries. So I want everyone to just think about, constituents or maybe yourself were complaining about, man, I can't find any apples, I can't find any bananas, I can't find any fresh food to make a good salad. And it was an inconvenience for a couple of weeks, but things got restocked. This is the life that many people live, unfortunately, in my district and across our state, and unfortunately, primarily Black and Brown communities that don't have access to fresh food. We need policies that are created to support equitable food environments throughout the state. A food environment is defined as a set of factors, physical, economic, and social, that influence where an individual shops for food and what kinds of foods they purchase and eat. Factors include proximity to food, affordability of food, available food options, services that provide food, marketing, advertising, social networks, government policies, cultural norms, and market forces. Equitable food environment is one that is inclusive and supportive of all people, given that, not everyone has access to a car. Not everyone has access to the best public transportation. It's an issue that we have here in Baltimore. So it's something that we have to always think about is getting these fresh food options into these communities. The purpose of this bill will be for us to require that really detailed maps are made in order to properly determine what is missing in these communities and what these maps will allow us to do. And the reason that I've offered to make them done by legislative district is that we know that there are forthcoming policies and ideas on how to encourage grocery stores and other fresh food options to come and suit certain communities. A lot of those policies are going to be dependent on us passing certain legislation for our individual districts. And I think that if these maps are made by district, as people look and decide on how to ensure that the policies are working or the policies are going to address certain communities the right way, I think doing it by legislative district is the proper way to do so. I would love to show you, I think last year I showed you all a map. What I'm going to do right now is instead of sharing the screen, I'm just going to drop the map that we have here for the 40th district into the chat, and you can look on page 2. You can kind of see what the map would actually look like. And what it takes into account is many factors that are critical in order to assess what the food index is and the availability of fresh food. And one of the things that advocates who are against bringing in certain policies that would make supermarkets more advantageous in certain communities, they say that fresh food is there. They'll say, oh, they sell bananas at that 7-Eleven. They sell apples at that Royal Farm. So we know that these are not adequate, reliable food sources that are equal to a supermarket or another type of store that specializes in having fresh food daily at prices that are affordable for communities that they are within. The issue that we have to address here is just making sure we have fresh food access to everyone, and having these maps and having these detailed information will allow for us to ensure that any policy that we move forward with is equitable and is actually addressing the issues. Now, I know that in the current bill, it has it starting in July 1st, 2022. We would need to make some changes there to make it start a little later so that the departments have time to prepare those. I know that the big thing that was an issue last session was the cost. And it appears that this year, they're even 7 times more expensive now from last year to this year. So I'm just like, where are these numbers coming from? And I've had many conversations with planning, and it seems that I'm not really even clear. They can't give me clear answers on where they're getting some of these numbers from. Number 2, they are assuming from the fact that there is not already data present that they can already use, which we advocated for. This, a lot of this data is already here. It's just a matter of aggregating it and putting it into one place. So a lot of the money that in the fiscal note that they're saying is going to be needed is pretty much assuming you're starting from scratch and there's no other data points to gather from. I think it's a dangerous assumption. And I think that we have to figure out a way to make this work. And I'm open to friendly amendments to see what we can do to maybe lessen some of the metrics, but still make sure that the metrics that we need to be as equitable as possible in order to make it happen. So asking for a favorable report on House Bill 179. Okay,
it looks like Delegate Boyce has a question.
Thank you so much, Mr. Chair, and thank you, Delegate Amprey. And I'm wondering, is it possible that the fiscal note is high because there is no direct definition in law of what a healthy food availability index is, nor is there specifics about what that index would be, other than asking to mimic, I know what the city has done. And is that the plan, is that you want them to use, the state to use what the city kind of put together? I think it's just unclear about what the actual metric would be and what that definition is.
Yeah, my goal would be for the definition to look like what John Hopkins and Little Futures has put together. They've used, it's a model that works. It's a model that has gained national attention. And again, the issue I have with the fiscal note is that a lot of this information is already available and made. We're not starting from scratch. So I understand what they're saying, but I just, I'd have to talk with them in more detail, and we have plans to talk and figure out where we can get to the bottom of how we're getting at these.
Well, it looks like the fees go down, but it looks like there's an assumption that there's an ongoing cost because you would need to continue to, I guess, produce this information yearly, biannually, stay on top of it. So I'm wondering if a lot of the costs as well, I'm just hoping this is helpful, is that it's because they're assuming there is a lot of preparation to get this started, that's where the majority of the costs would be, and then it would somewhat dwindle down as the kind of like the system begins to work and the kinks are worked out, and there's something that they're just producing every year per whatever sources that are coming from this. But I'm sure we can talk about this more in detail.
I neglected to see that there is a person signed up in favor. So let me go to Human Haidarian with Fair Farms, Maryland. Forgive me for not calling you up sooner. So you have the floor. Welcome to the committee.
Thank you, Mr. Chair. Yep, no problem. Again, my name is Human Haidarian, and I'm the new Fair Farms campaign manager. We humbly ask for a favorable report on HB 179. I believe from my previous experience, being a farmer, volunteering in food banks, and just being in different environments and talking with people who are hungry, not feeling hungry, who are hungry. There's a difference. That what does not, in a policymaking process, what does not get measured, does not get managed, and therefore is ignored. And people that are hungry should no longer be ignored, ever. Especially, and we've seen it during this COVID-19 pandemic, clear as any time before. The state that we live in, as like that, we would consider food apartheid, meaning the segregation of people who have access to fresh and healthy foods and those who don't, should end. This is a term that was coined by Karen Washington, going beyond the terms of food desert and food swamps. That's something that has been structurally created by the state and society that we live in. And so I would like to thank Delegate Amprey and his staff and the stakeholders and their leadership that are involved in creating this bill. And we hope to work together more in the future, opportunities for collaboration on these types of legislation. Thank you.
Thank you, sir. We have another, Delegate Boyce, do you have any further questions, or? Oh, you don't have to panic there. Okay, the Vice Chair has a question.
Thank you, Mr. Chairman. Delegate Amprey, I'm sympathetic to what your legislation is attempting to do. Just going back to the costs as reported in the fiscal note, and I know you said you're going to have follow-up conversations with the department, but fiscal note says that they assume that every retail food store in the state must be surveyed, and some other points about data collection and analysis. So I guess just maybe wanted to ask if if you thought it wouldn't be necessary to do such a canvas as talking to every retail food store in the state as an example, maybe the cost could come down.
Yeah, I'm totally open. I understand that Hopkins had a lot more money, resources, and time. Also, it was right in their backyard, being Baltimore, to put together the maps that they had. And I understand that we may not be able to mimic it exactly, but I think we can get close. I think we can work with some assumptions on grocery stores and what they provide and their availability. But I'm more than willing to change some of the metrics. I think at the end of the day, we just need to know, within a certain, proximity of certain areas, what is the access to fresh food on the regular. And I think that there is something we can do to better have this mapped out so that we can properly create policy that will get rid of these. It's 2020, it's 2022, man. I can get on my phone and order any kind of food I want, but people still can't get the fresh food. We gotta make this work.
Thank you.
Delegate, I've got a question. You mentioned this briefly, but I didn't quite catch what your reasoning was. Explain to me again why you want to do this by legislative district.
So yeah, I'll cut to the chase. So last year I was sitting on some hearings as I was waiting to speak, and there was some bills put forward in, I believe, Prince George's County, in which they were trying to provide some pathway to having a beer and wine option for grocery stores in certain communities in order to get those grocery stores into those communities. And there was pushback by certain people who were that don't want to see beer and wine in grocery stores. And one of their arguments was that, I heard the argument 3 times that how do we know that this is really a food desert? Like, we don't really know. Like, and one of the arguments is that you can get fresh food at this 7-Eleven, you can get bananas every day. So this map isn't really, someone they had used a different map. So I think that at the end of the day, the reason that I would like to see it this way via legislative district, and I'm open to it being done another way as far as the maps, is that, when we think about, the pathway for when we actually impose certain liquor laws across our state, we do it by district, right? So I think that if we had these maps by district, it would make it a little easier there. But I'm open to making that amendment, and I'm open to doing it other ways, just to make sure we have every part of Maryland mapped.
Well, I think the reason for some jurisdictions basing their liquor licenses on senatorial districts is because some jurisdictions, I think Baltimore was like this 30 years ago. I don't know what's going on now, but you had to have the support of the senator to introduce the legislation. I think it was something political like that. It wasn't a public policy reason, but yeah, we'll find a way to do it. But anyway, any further questions for the sponsor or for any of the or for the witness? There's nobody signed up in opposition. So if I see no further questions, then that ends the public hearing on House Bill 179. And that ends the public hearing today. So announcements. Do any subcommittee chairs have announcements?
Not today.
Anybody?
No.
What's that?
Not today.
Not today. Okay. Delegate Holmes has his hand up.
Thank you, Mr. Chair. The Housing and Real Property Subcommittee, we're not going to meet today. We're going to meet tomorrow. But I just want to let you know in advance, we're meeting tomorrow, and need to apologize to the Housing and Real Property Subcommittee that you have not received a list of the bills to be discussed tomorrow, but they will be forthcoming very, very soon. Thank you, Mr. Chair.
Okay. Any other announcements by subcommittee chairs?
Mr. Chair.
And, yes, David.
Just to put a little pin in it, Thursday will be motor vehicle, just as usual. Thursday. Thank you.
Okay. Anyone else? All right, any other member of the committee have anything they want to say before we adjourn? Vice Chairman.
Mr. Chairman, I guess I should repeat my announcement as well from last week that the Environment Subcommittee will be meeting tomorrow after bill hearings.
Okay. All righty then. In that case, have a nice afternoon, people. See you tomorrow.